this person innocent during the course of this trial, and if this was about Mr. 61? Mr. 61? Miss 59, do you have any reservations about your ability to breathe life into the presumption of innocence when it comes about the horrific murder of a New York kid? Miss 59, do you have any reservations about your ability to breathe life into the presumption of innocence when it comes about the horrific murder of a New York kid? Miss 59, do you have any reservations about your ability to breathe life into the presumption of innocence? Well, that's one of the things of the whole transition. I think a lot of time what kind of some stuff has, you're going to have to, in this case, it shows me one of people sure, like an autopsy photos of the dead 11-year-old kid, been decomposing for a while, and you got to look at those photos to determine that because there's evidence your guy was going to be important. And some people do it, and some people just thought of it as getting emotional and they can't do it no matter how much I ask them. Like, I can't talk to basketball. Some people, I can't look at that and be rational about it. And I know Miss 65, I see you getting emotions. Oh, maybe not. It's not far back, so.
As some people were saying something earlier, I love that too, but it was like, your previous question.
Breathing life into the presumption, breathing life into the concept, it's a due process, right? Everybody in this country is accused of a crime, has that right, no matter what they've been accused of. And that's why we're taking, we know that it may be hard to get, I guess, for some of us to do something. That's why we're taking the time. And only you can answer these questions. Like, yes, I do super personalities. That's all I'm good at. You know, if somebody's saying, hey, can you dunk a basketball? There's no way I can do it. Can I hit a 3-point shot? One side of every, 2 out of every 10 shots. Okay? There's like a layup. Boom. I'm going to get that 90%, time. I'm just trying to gauge where people are.
Yeah, no, I think, and I don't think that's not makes this, but
Yeah.
That's kind of. Would I be able to?
Would like a plug? Miss 74? What do you think about that? Some of the evidence, I mean, you're going to have to see autopsy photos. That are gruesome. You're going to look at them to see what those autopsy photos are trying to tell you. How confident do you think you can, because again, that presumptive innocence goes all the way through trial. Breathe that in. Breathe into that concept even after seeing those photos. Can you do that for this guy? Number 69. Number 49.
Yes.
That's as he says. Yeah. I see you raise your hand.
It's the severity of the situation.
The 70.
Instead of being sold.
No, absolutely. And I guess the way that I would rephrase this, I'm doing this kind of almost like a job interview. I've done a lot of cases. I've had cases where jurors said, I have to look at autopsy photos. I'm not doing it. You make me sick. You can't make me look. You can't make me that type of thing. And there's a lot of people like that. And so I'm trying to get a sense. One, I want everybody to know what this job is going to be. And then, to see who's going to be best to have that job. Does that make sense?
I guess my other question to you is, it doesn't, so
Be quiet.
So
Okay.
I'm just saying, if I sat here and I'm like, you know,
If,
I know that I can maintain an expression
no one,
on her face. Do it. I mean, would I do that for 8 weeks?
no,
Ability.
no, and I just want to be clear, I'm not asking that. No one's asking that. And if you're telling me you could do that, I know that you've already messed up rule number 1, which was to be honest. There's going to be emotion in the next 8 weeks of this whole thing. The question is, can you have those emotions come up and set them aside and still jump in essence, hold the burden, look at all these facts like that? Or, is this going to be something that I have concerns as I am right now? I can feel the emotion coming up that I'm not going to be able to do that. That's kind of what I'm trying to get at. Does that make sense, Mr. 29? All right.
I think this, I almost don't get the scenario to expect the state jury starting and saying, yes, this thing is this. We have both sides presenting evidence, trumping that's us. One way or another, it's trying to convince us that we serve the country. So to sit there and say that until after 8 weeks, in 8 weeks, when I walk into a jury, that's when I can start one of the hearings. Imagine, you know, sitting in that jury, these evidence of the month, asking the court to have given the adult and the larger fish, for the defendant of this is
It's a little bit, and the law, like it says, the law required is for you to presume your innocence, and that presumption of innocence, according to the instruction we get from the court, maintains throughout the trial all the evidence up to they're done talking and out of their talking. And I guess one way I've analogized it is, do you like James Bond? You've seen James Bond movies? Oh, yeah.
so I guess.
Okay, and you go see a James Bond movie, and you're watching all the movie, and no matter what happens to James Bond, I think he's getting out. I mean, he gets tied up like this. He's got a laser coming up right there for him. He's telling him all his evil plans. But I'm presuming that James Bond is somehow going to get out. I'm not ignoring the situation, but that's how I think this movie's going to end. And if that laser came up and cut James Bond in half, I would be shocked. But that's, I guess, the nearest analogy that something's going to happen that you presume that you're going to be the innocent until this case is done, and you go back and you can look at everything all at once. And it's not saying that you don't make opinions while it's going, but it's at the end of every day, say, these are all the stuff I've learned, and when I come here and you said every day, I'm going to presume I'm going to find you not guilty until the end. You don't ignore all the stuff that they're doing every day, but every day we got to put on a presumption of innocence hat, come in and go, one of my jobs today is I presume for innocence. Things are going to come in, you're going to have opinions, but put that back hat on every day. Does that make a little more sense?
Yeah, a little bit, yeah. I don't know if I was going to go to the jury.
No.
Go to switch, because now you get.
No, we want you thinking the whole time. We want you thinking the whole time, but it's just, we want you thinking from the perspective that you believe that she's innocent, and they've got to change your mind. You know, that I guess that's the easiest thing, you know. Everybody has their different politics, you know, and you go into one thing and you think, I'm never going, I just read everything like that, and people try, you know, to change your mind. It's your politics up until the end of the day where she's not guilty. And they're going to be trying to change your mind, and everything they say, you put in there and you think about it and you form opinions, but still every day you got to come back and presume innocence. Can you do that number one time? Okay. All right. Anyone else? You know, I don't have a lot of trying to pop around anybody, but this presumption of innocence, even having to look at some horrific photos, it's not. What do you think about that? 69. Maintain a presumption of innocence, even have to look at autopsy. All right, let's move along. Oh, no, we're going to let you go, so don't worry. So look at this. See how nice I am. You're now that stress is. Yeah. Yeah. And you form anger towards that person because you've got a kid that's come in and hurt, and the kid didn't deserve it, and it pisses you off, and you want someone held accountable. Everybody feels that way. You got a kid that's hurt. Your initial instinct is, I want to hold somebody accountable, and somebody has got to pay the price. And that is human. But that is not all people's job. Who's going to be on this jury? We'll have more than that, and we'll be alternate. People are going to be on the jury. It's not vengeance, even though that may be an emotion we all have to feel. We all have to put, whoever's going to be on this jury is going to have to put that emotion aside and determine whether or not they approve this case beyond a reasonable doubt for the facts or the elements like the omelet, and whether or not they prove that she was insane beyond a reasonable doubt when this happened. And so, does that make Miss 28? I wouldn't want someone coming in here and say, it doesn't piss me off that an 11-year-old kid's dead. But
Think about what happens to the person who's found guilty. What's up to the judge? Vengeance. That is the weight and authority of vengeance. Consequences of whoever responsibility. We're trying to figure out if this particular person that is guilty. We don't want somebody to be found guilty. We have to figure out if that person's guilty. If that person's guilty, then let's throw a book out. If they're not guilty, then let's have another trial. Let someone else do it. That's what it's about. Innocence. It's free. Very strong. Rather than a person, innocent person versus a guilty person.
neither one are ideal. But that's our system design. Our system design that is better for a guilty person to go free than an innocent person being convicted. And no system's perfect, but that's how ours is. I'm guessing I'm running out of time here quickly. A lot of people had thoughts about not guilty for reason of insanity. Miss 21, you indicate you put on there that you think it's for cowards. Yeah, and that's all I want.
And I just have a question.
All right, well, I mean, who thinks not guilty by reason of insanity is a BS defense? You got Miss 62, correct? It's okay. Yeah. And would it be fair to say it'd be harder? Because in this case, they have to prove beyond reasonable doubt that she was sane. They have to disprove it. What I'm getting from you, you're not really buying that as a legal defense. That's okay. Okay. Juror number 69, you feel the same way? Number 47? Oh, don't worry, you're fine.
You wrap up.
Number 53. What do you feel about in your eye? Juror number 70, you have a degree in psychology? All right. Yes.
No jury by trial and not given an opportunity appears. But I know what happens. We're just sitting based on 10 reasons.
I'm thirsty.
So I'm just saying, there, I do have that bias, which is anybody who is in for the court, I understand the question.
All right, it's enough.
Juror number 60. No, it's good. Oh, it's good information. That's all I'm asking for, just to be honest. Thank you for being honest.
Last question.
Number 61, you indicated you don't believe in medical reason that you think it's an excuse.
I wanted to follow up on a couple of things. Juror 47, are you the one that said that you were not going to be here on April 21 because you're moving? Are you moving to Denver? And so remember when we started out this process this morning about are you a county resident or not? Okay, that was what I was trying to get to. So you're planning on moving to Denver. You're going to be there about a year. Okay. All right. And then juror number 62, I had a little bit of difficulty hearing your answer. Did I understand correctly that you had served on 2 juries? Well, you should play the lottery. Okay, and were they on criminal jury? Were the cases criminal or civil? That would have been a criminal case. Probably a criminal case as well. Let me ask it this way. When you were on those juries, were there 6 of you or 12 of you? Okay, so they would have been criminal cases. Okay. Okay. So you've been through the process a couple of times, and I did not hear your complete answer regarding whether you can or cannot give the presumption of innocence to someone. Okay. Okay. All right. And, all right. Juror 59, you had said that you had the 21-month-old and you'd figure it out if you needed to Would it help? I'm sorry, juror 65. Juror 59, you probably don't have a child care issue. But juror 65, you're the one with the 21-month-old, right? Okay. And you said that you would figure it out if you had to, or you needed to. And actually, I'm right. Juror 59, you have a child care issue too. So the question that I have is, we have court care that is available in the courthouse. It's on the first floor. Juror 65, yours is 21-month-old. Juror 59, your child, though, is coming home from school, right? Okay. So juror 65, if you were able to bring your child into the courthouse on days when you could not find care, there's some parameters that we have to work with, but it's primarily my issue, not yours. So I got to make sure we get you out timely because court care closes down, I think, at noon. They don't reopen again until 1. So we have to make sure that regardless of where we are, I just tell the lawyers you're done for now. So that gets you out of here so you can go down. Would that be helpful?
No, excuse me.
Okay. Memorial, Maine or north? Okay. Yeah, not very far. Okay. And juror 65, sorry, juror 59, let me make sure I understand your situation. Is this going to be an issue for, I mean, if you're here 6 weeks or so, how much of a problem is this going to be for you to get your son, right? 10-year-old home? 9. Okay. All right. And juror 66, you would talk to us a little bit about your memory problems. How long have you been retired, sir? And what kind of work did you do before that? Okay. And how are you doing with your memory today? Okay. Does it vary day by day? Or is it just over a period of time? Okay. Yeah, no, I get that. My children tell me I have the same problem. It's amazing, though. They say, Dad, forgot about this. And other times people say, are you ever going to forget about that? So, I mean, okay. All right. At this point, what's going to happen is we're going to take about a 15-minute recess. So I need everyone to leave the courtroom. Same thing as this morning. Remember where your seats are. I'll have you come back at 3:20. So be ready at the door at 3:20 to come back in at that point. And then what will occur is that the attorneys and I are going to have a conversation up here, and we will discuss jury selection at that point. So all rise for three, please. Thank you. You may all be seated. Record should reflect the jurors have left the courtroom. We can do this in one of two ways. I assume Ms. Stauch would like a break at this point in time. Okay. We can do it one of two ways. We can have her take her break now, and then come back and do challenges for cause. We can do challenges for cause now and then take a break. I don't know if you want to waive her presence while we do the challenges for cause. It would be my preference not, but pardon? Okay, so you just need to tell me whether you want to break right now. Okay, no, that's fine. That's fine. We'll do it now. All right. We'll be in recess then for about 10 minutes.
So did you ever see any of the Austin Power movies?
Yeah.
So,
So I think they're trying to be pretty accommodating. Pretty interesting listening. It took me forever to get my sound to work. Forever. You gonna go outside? Gonna go outside and go party? girl's hungry. No, you're thirsty. Enough food. Sorry, guys. My dog is drinking. My goodness. Don't drink so much that you get it up.
Probably not the same language that we've already reviewed in the policy. I would think that you also be noticing something like that for actually the.
Yeah, that, I have the same recollection as Mr. Allen, and I'm looking at the questionnaire. And I think what juror 69 actually said, on the questionnaire anyway, was that she has opinions regarding insanity, and she said only if it applies, not everyone who pleads this is insane. And I don't recall any specific comments from her otherwise. And I think that's just an accurate statement of the law that, you know, sometimes it's raised as a plea when maybe it shouldn't be, but that doesn't mean that she can't follow the law in this case. So I will deny that one as well. 74.
74 had on questionnaire in regards to not guilty by reason of insanity. I believe anyone that hurts a child is crazy, exclamation point, but is not.
So they're
a
going
reason to
over
get
the
off or be
answers.
found not guilty.
Yeah, I remember that one. I wrote that one down too. Mr.
And
Allen?
whether or not they will be fair or not.
So, notes that, it's already on that figure that she agrees, or we could do that just in the sense of, and also, I love that, I would like to make a city person.
Well, I put the comments from juror 74 in a different category than I do for jurors 59, or I'm sorry, 59 and 69. I do agree that the comments, I mean, essentially what she's saying is this is not a reason to get off or be found not guilty. There wasn't a lot in the way of questioning of juror 74. She would have been the one in the far back row, far corner. And so there was not a lot more to go on, but based on the questionnaire, I just see that as, I mean, if you look at it, see 74.
She has the exclamation.
69. I got the exclamation point. But if you look at the difference in tone and tenor between 74 and 69, 69 says, well, only if it applies, not everyone who pleads this is insane. And I think that's an accurate statement. But clearly I get the impression from juror 74 that she has significantly strong opinions regarding the use of a sanity plea. And it also is even much worse than juror 59, who on her questionnaire asked, you know, well, what was the history before this crime? Would that explain the plea? Is it being used to not accept responsibility? And I think that that's a logical question, and Frank, probably one that will be at the heart of the case. So I do agree that, or I am going to grant the challenge for cause as to juror 74. So let me make sure I have everybody here.
And I just love it.
Don't interrupt me for just a moment. That's all right. I just want to make sure I got the numbers in the right spot. 62, 4, 15, 66, 66, and 74. Okay. So you guys want to follow along with me as to who everybody should be that is excused so that we all agree on the same numbers? Or you just want to come up and look at my sheet?
No, I was going to say 70, but.
No, we want to hear it.
Okay. So you want me to read the one that are excused or the ones that are still on? Because a lot fewer that are still on.
Probably easier to read still on.
Still, okay. All right. We still have juror 2, 7, 9, 20, 26, 28, 29, 34, 35 and 36 have been, yep, I need to get those crossed off. 39. So the next juror that we have still on the panel after juror 34 is juror 43, 44, 45, 47, 49, 54.
Oh, I thought 47 was.
I don't have. Oh, whoops. Yeah, she is.
I thought it was on the yellow sticky.
You're right. 57 was on the sticky, was on the post-it.
47's also on there.
But
Yes, and about 7 more.
okay, so let's go back. We have jurors 43, 44, 45. I'm going to excuse 47 because I'm a little bit concerned. I understand how she sees residency. I'm not sure that I agree with it entirely, but certainly she's going to be gone by during part of the trial. So we have jurors 43, 44, 45, 49, 54, 56, 57. That's right. Yeah, he was the administrator. 58.
Hi, what are you doing?
Oh, there he is. So 58, 59, 61, 65, 69, and 70. Those are what I have as our jurors. You agree? Mr. Allen? Mr. Tellini?
I agree.
Okay. All right. Let's go ahead and let him back in, Todd.
Wonder if
Yep.
the ones will be glad they're dismissed.
You can get a copy of that if you want, if you need it at the end of the day. Kathy, you can get a copy of that if you want at the end of the day, if that'd be more helpful. Okay. Oh, the total left. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. Is that what you have? Yeah. Okay. Kathy, do you need a hard copy of this? Okay, we'll get you one. Yeah, that's what I was wondering about. Yeah, that's fine. Okay. We're going to do this a little bit different than what we have done everyone else because it is frankly easier to read the names of the people, or I'm sorry, not the names, the numbers of the people who will come return for further jury selection on April 3. So I'm going to read those numbers. If I read your number, stay in your seat, because I'm going to have further instructions for you. And then everybody else is excused. You can go on about your business, do whatever you need to do today, those sorts of things. But the people whose numbers I read need to stay in the courtroom. So potential jurors in this case will be number 2, number 7, number 9, number 20, number 26, 27, or I'm sorry, 26, 28, 29, 34, 43, 44, 45, 49 in the back there, 54, 56, 58, 59, 61. Going into the row behind that, 65, 69, and 70. So those people need to stay where they are. Everybody else is excused. If you have a question as to whether you're supposed to stay or not, raise your hand. You are 24, you are free to go. We just have them do this from their seats. Oh, stuff out, yeah. That's fine. Okay, thank you. Okay, I have an instruction that I want to give you, and then we're going to ask for some information. You've probably already guessed that there is some public or media interest in this case.
No.
There could be more in coming weeks. You must guard against that, as you will be required to decide this case based on the evidence presented and the instructions that I give to you. You can tell your friends and your family, significant others, people that are important to you, you can tell those people that you may be on this jury and how long you think it will go. You can ask for their help in avoiding exposure to stories or even opinions from others regarding this case. But you cannot otherwise discuss anything else about this case with anyone. And you should not listen to any opinions regarding this case from someone who is not a juror. And we'll talk about that in just a moment. If someone asks you why, just tell them it's because that's what the judge told you. That puts the burden on me and not on you. Because I know that in every case that I have, we get to a point where others know something about the case and know that they might be on the case. And at the end of the day, we will have testimony or evidence in some fashion. And I know when I go home, I have a lovely wife who I've been married to for more than 30 years. She's going to ask me how my day was. I will start to tell her. And while my wife is a lovely wife, she also has very strong opinions. And she is happy to share those opinions with me, whether I want her to or not. So she'll ask me how my day went. I'll start to tell her. And at some point, she'll look at me and say, well, you didn't really believe that, did you? And pretty soon I'm having a conversation with someone about what I should and shouldn't believe. And that person wasn't even here. You can't do that. So the way that you avoid all that is you say, I can tell you that I might be a juror on this case. We think it's going to take 6 weeks. We believe we're going to start on April 3. The judge told me that I can't tell you anything else about it. Please help me to avoid exposure, news stories. Please help me, my friends, once they find out that I may be on this jury, may be wanting to share their opinions with me. Please help me avoid that. And tell them the judge said that I can't talk to him about it. As I said, that puts the burden on me as opposed to you, because if I were to tell my wife, look, I'm just not going to talk to you about it anymore, it would lead to an entirely different conversation. So this avoids all of that. You can still blog or communicate with others. You can go on about your normal life. You just can't talk about this case. And you can't do any research about this case, the people involved in this case, the witnesses in this case. You can still watch TV, you can go on the internet, you can still do your Amazon shopping, all of those things, but you are not allowed to look at, read, consult, or use any material of any kind, including any newspapers, magazines, television and radio broadcasts, dictionaries, medical, scientific, technical, religious products or materials, or the internet in connection with your jury service. I want to emphasize that you must not seek or receive any information about this case from the internet, which includes all social networking, Google, Wikipedia, blogs, and other websites. You're not allowed to do any research of any kind about this case or this kind of case. What we're going to do, and so that you know what the process will be going forward. You've all been through this today. We're going to do this every day, not with you, but with a different group tomorrow. We will do this every day until we reach a group of 110. Once we reach a group of 110, we will bring the first 75 back. Our hope is that we're going to do that on April 3 at 9 a.m. A couple of things. Mr. Combs and Mr. Sproul are going to circulate around a sheet. What we would like for you to do is put down your name, your juror number, not your seat number, but your juror number, an email address, and a phone number. The attorneys don't get that. Nobody gets that. That stays with us and nobody else. The reason for that is we will let you know as things progress how it's looking. It is possible that we will not have our projected number of jurors by April 3. It's possible we might have them earlier. But what I want to do is keep you advised about where we are if it turns out that we're going beyond April 3. We have to. I don't think it's going to be that far beyond it. So we need to keep advised of that. In addition, it has our contact information on it. You should have given, they have cards, right? Yeah, okay. You have a card. We're going to be giving you a card that has our contact information on it. It has my division, my name, my phone number. We also have an email on there. And it tells you to come back on April 3. If something happens, and I've been through this before, so I know that things can change in the next 2 weeks. I don't wish that on anybody, but I know that emergencies can happen. Something can happen in your family. Maybe you can't win the lottery and you decide to go to France. I don't know. But things can happen and things can change. So you need to call us and let us know. And if it's an emergency or something like that, just call us, let us know, and we will deal with it. Okay. So the reason why I'm doing this and saying that you can enlist the aid of your friends is because I try to learn from past mistakes. And I had a case previously where I said, you can't discuss anything about this case with anybody. And unfortunately, I received a call from a husband who was he was anxious and he was upset because his wife was, I could hear her in the background crying and saying that she had to be here for 8 weeks and couldn't tell him why. So you can do that. You can explain that to your employers. You can explain that to anybody. Juror number 9, you can talk to your professors about it. If you need a letter from me, let me know. If anyone here needs a letter from me to explain to their employer what they may be doing for the next couple of months, let me know. And I can see what I can do. I can certainly get letters out. Certainly, if you are selected as a juror in this case, I have no issue with providing you with those letters. So, but we need to make sure that 2 weeks from now, you are qualified to serve as a juror in this case. The attorneys and nobody from the attorneys are going to be contacting you. Nobody from any other source should be contacting you. If that happens and it becomes a problem, let me know. And I will take steps to deal with that. But your contact information stays with us and nobody else. So that's where we are. Let's go ahead and pass that out. Oh, okay. Mr. Allen? Yes. Somebody, I think it was juror 15 who is no longer with us. She had discussed an issue about, what sort of punishment might be involved or something like that, or she would have some difficulty deciding punishment. You need to understand that if you are selected to serve as a juror in this case, you will not be deciding punishment. The only issue that you will be deciding is whether or not the prosecution has proven everything that it is required to prove in order to establish the guilt of the defendant beyond a reasonable doubt. This is not a death penalty case where the jury decides the punishment. If the defendant is found guilty, it will be my job to impose or decide the punishment that should be imposed, and only my job. So your job is really just to determine the facts of the case and whether or not the prosecution has proven beyond a reasonable doubt everything they're required to prove. So hang on to those cards.
Did they end? I had to let the dog out. Well, that was pretty interesting. Too bad I couldn't stream it all because I couldn't figure it out, but now I think I have it figured out. So, till next time. Thanks for joining. If you watch, please give me a like. Oh, wait. Did they forget to turn their mics off? You did that earlier. What do you want, a cookie? Come here. Come here, you can have a cookie. I didn't hear if they were ending. Oh, girl, you are thirsty today. Did anyone hear if they said they're done? If you ever want to come up, let me know. I will drink. Link drop. I'll drink block. I'll wait a few minutes, see if they come back. Well, I didn't hear him say that they're ending. So hang on to your cards. After saying it was his job to give the sentence and not the jury's. So we wait. It sounded like they finally turned their mic off. Does anyone remember how many that was? Because they're going to get more. Gregory Warner is the judge. I wonder if he's going to, yeah, he's going to be the judge. You are so thirsty today. Yes. Sorry, my dog is thirsty. We just found out a few weeks ago she has cancer. She's 15. Nope. They're still on mic.
Okay, no, we're done.
Hot mic, hot mic. He needs water.
We're using gold tickets for that, right? The yellow ones. That's the other thing I was going to do.
All right, Judge, you need to speak up. I think he said he forgot to do something. Uh-oh. So what do you think of them allowing people to air this? Do you think it's pretty neat? Pretty neat process there. I don't know if I could do it. Because like her, I already think she's a scumbag and
All right, I want to check on a couple of things. The first is, does everybody have a yellow ticket? Raise your hand if you do not. It looks like that all taken care of. Keep that with you. In addition, when you come back on April 3rd, you will come back to the jury assembly room. So where you reported this morning, you don't have to go there. What you need to do is, it's going to sound strange, but you got to report to the hallway outside of the courtroom here. Because what will happen is, remember how we stacked y'all up out there this morning? That's what we're going to do on April 3rd. Your seats will be renumbered. You don't have to remember where you are because we're going to reshuffle you all again. But be out in the hallway, and then when when it comes time to start the questioning, or we call it voir dire, when it becomes time to do that again, we will open the doors, and Mr. Sproul and Mr. Combs will tell you what seat number you're in, and we'll go through the whole process. So just wait out there in the hallway until we're and then juror number 7 would be juror number 2. So we don't reshuffle them, and then our current juror number 2 ends up as like 63 or something like that. Okay, so these people, well, these 20 will be in that box.
So they'll be the presumptive.
They will be right. Yep, that's exactly right. They will be the presumptive panel in the 20. So yeah, that's where we will be. And we'll have to talk about, as the day goes on or the week goes on, I can talk with Mr. Sproul about when we might be able to get that to you. It really just depends on how long it's going to take. I'll know once we start getting to about 80, I'll have a better idea about how long it's going to take us. So, but
Judge, so we know we've already put the jurors' questionnaires that have been eliminated today in this box.
okay,
We'd like to keep the 20 that made it through. We'd like to keep their questionnaires just because we could be asking them questions in the future.
not today.
Not today.
I'll think about it. I'll think about it overnight. whether you get them or not. My thought is that probably not until the end, largely because you're not going to be asking them, you won't be able to ask them any questions until we get to that 110. And it may be once we're there, then you have all of them, and that may be appropriate. I just have to tell you, I'm very cautious about letting any of these out of my sight for lots of different reasons. But I agree that you should have access to them. The question is when you're going to get it. So let me think about it. I'm more inclined to say wait until we get to our pool of 110 or whatever, and then you can have the questionnaires for the 110, as opposed to you need to hold on to these for the next 2 weeks. So.
I actually thought that you were going to go last week. And it's actually going to have to go with that first one. I think the court could, to satisfy any concern, they should have protected these additional substances.
Actually, as I look at what I've highlighted, I have 19. So
You have 19 there?
2, 3, 4, 5,
You
6, 7, 8,
You need to look at your sticky note.
11, 12, 13, 14, 15, 16, 17, 18. I have 19.
So,
9, 20, 26,
8,
28, 29,
34,
34,
1,
43, 44. Oh,
45.
45. That's what I missed.
It's 20.
It's
Counting 47.
we missed that's right. Yeah, so we did give
It's 20. My fault on the count.
Yep. It is 20. Yep. I did not highlight one that I should have. Okay, so that's where it is. Okay, so I will think about that overnight. If we put those in, just the ones, if we put just the restricted ones in as sealed, only the attorneys would be able to get access to them.
I don't know. Now, sometimes you go in there and it says only the judge can see this or administration.
So that's sealed, restricted. Let me think about it. The answer for right now is no, give them back, and I'll think about it. And overnight, you may get them back.
Would we at least be able to keep can we grid notes on our packets to keep them separated? Like
Yes.
Constitution and defense?
Yeah. You got a paper clip or something? We can do that.
But what? This is it's the same. We have 2 spots.
Okay. Let me think about it.
This is all everything that you got. Yeah. You have your chart. The chart, Joe?
I'm sorry. I was.
The chart.
Oh,
You need a chart.
yes. We do need the chart back. And the chart's not going to do you any good anyway.
That's what it's like. I've got so many notes written on this thing.
Hand it back and I'll tell you tomorrow.
Better start writing on a notepad. It's like,
Well, the concern is if somebody wants to tell me or give me an idea, the concern is I don't want any of that information out floating around anywhere. So I could put a protective order of you can't do anything with it. But I'm not sure how to police that.
Well, I think you should do that from the court orders, because we do that with other things.
That's true.
And then on top of that, I mean, there's so much deliberative process as to how we're going to ultimately the jury and every challenge that relates to notes that are on those forums. That it'll be hard to recreate that without being able to go back and access that notes.
Yeah, and
There you go, baby.
it may be that the order would be that you can't disseminate it, you can copy it, can't give it to anybody else. And when we get to the part where the jury has been selected, get everything back and it's all destroyed at that point, because then it's not going to matter. Right?
Right.
But I understand the utility of you guys are taking notes as we're going along, and it's helpful to have those notes. And you don't want them to see what your notes are, and they don't want you to see what their notes are. And that's fair. I mean, I understand that. I'm going to think about it overnight, and I'll let you know tomorrow morning. And then you have the original, right? This is not the one that we're keeping.
I have a copy.
Is this the one that we're going to keep?
As original as it gets.
Okay. I told Kathy I'd get her a copy of what all of my, you did? So you're good? Okay.
Over here, and I was trying to get it out.
We need our parcel unit.
Yep. You can leave anything in here that you want.
Can I sleep in here, Judge?
It's your choice. I will tell you that, let's have the conversation about microphones. I got to have one on the table. It's not as critical during jury selection. It will be during trial.
I guess the concern is just based on the recent trials that I did, that needs some context for example, conversation. So and then people, I just put on one computer myself.
Can you tell me what that was and when it was?
Yeah, see, statute trial that it shows.
Okay. Findorf, right? Okay. I'll check on that. Well, that's a legitimate concern. I did not know that. And that's a legitimate concern. The problem I have is that I need the microphones there during trial so that if somebody objects, I can hear it, because I'm usually focused on the witness as opposed to the lawyers. And so I need to make sure that I understand, but that's a legitimate concern. So let me think about that.
I'm fairly confident.
That's interesting to keep in mind.
That's
Okay. Okay. And the only other issue is that you have to talk loud enough so the court reporter can read. But that's a big concern. I get it. I did not know that. Okay. Because I do know one of the issues and one of the reasons why we have the microphones hooked up is in part so that the people on WebEx can hear, and they can hear well, but they ought not be hearing any of that.
Yeah, they pick up in seconds.
Okay. Let me, I've been advised I'll think about it.
That's
Yeah.
Every time we start, I get a text message from the office.
So you're getting messages too that are saying they can hear your conversations, because I obviously cannot.
So,
Okay.
I'm sorry to interrupt. There is a mute button on it.
Yeah, but you got to hold it, right?
You have to hold it, and like, you don't think we're gonna
Yeah, we're not.
think that like the
We're not
entire
doing
trial.
It's not. We're not doing that. That's reasonable. We're not doing that. So the question would be, I was not aware of this issue. I will see if I can figure out a reasonable workaround. So it's both sides of the complaint issue. Okay. All right. Okay.
And Your Honor, I know everybody wants to go, but in
Don't.
fairness, we had 2 attorneys for each defendant co-defendants in the case. Small
Right.
acting like sardines. I think probably something like this is probably going to be a little bit more conducive to remain anonymous in our conversations than it was in Division 12.
But you just said that you were getting, in this case?
Yeah, I got a text this morning.
So it wasn't the other, it was this one.
Yep, this morning, as a matter of fact, just to tell you, I got a text saying that they could hear us. FYI, I can hear your conversation on the web, and we were all sitting right there.
Okay. I'm gonna go to him right now.
You guys are
Okay, thank you.
I'm gonna go to the window. Well, so I'm gonna go down there. Okay, thank you. Stuff that we have stuff up here. Just stuff up here. Let's take a picture. Just cramp it up. Bye.
See you.
It's hot. It's like,
Got it.
bad and bad.
I'm gonna leave these witness list tables.
Well, this we need to do is food for this party. We do. We don't. It's our dog.
He's gonna.
Because I mean, I can give to you for now, or just I'll just keep. Actually, you know what? I'm just gonna stick it here because I'm coming back tomorrow. Is that okay?
That was my dog eating at me.
Okay. All right. There you go. You know what? I'll take it upstairs and put it right here. How's that? That works good.
2 minutes. I'll let you know.
Okay.
Here, which is. Open up, Mark. Oh, yeah, I think it's all good.
Ah, I lost him. Hold on. Oh, they might be done. All right. Looks like they're done. Not sure when they'll be back, but when they are, I will be back. Thanks for joining. Bye.